Reprise du débat. Resuming debate. L'honorable député de Notre-Dame-de-Grâce.
The honourable member for Notre-Dame-de-Grâce Lachine. Thank you, Mr. Speaker.
Mr. Speaker, I'm not a liar, I'm not a judge, but as a member of Parliament, I am a student of the law and a lawmaker. I speak for Notre-Dame-de-Grâce Lachine to represent the interest of the people in my riding. This allows me to understand and bring forward the concerns of regular Canadians. Like my colleagues, I am here to study Bill C-478, an act to amend the criminal code increasing parole ineligibility. I have several concerns with this bill and cannot vote in favor of it in its current state. The whole idea of changing sentencing to imprisonment for life without eligibility for parole from 25 to 40 years seems quite arbitrary. In fact, I asked the member opposite to propose this bill to explain his reason for choosing 40 years. Why not 35, 75, or 100 years? What motivates his decision to change the criminal code of this country? Many of my colleagues opposed will state that they are moved by victim rights, as if they were a black and white suit. But you cannot be either for and against victims' rights. I believe that all parliamentarians care deeply about victims' rights, and the Conservative government does not have monopoly on this. The NDP remains sensitive to the extremely difficult situations that victims and their families may have experienced. But Bill C-478 is not a bill about victim care, victim services, and I'm not sure that it is even in accordance with the Charter and the Constitution of this country. The bill is about tougher punishments, and a Conservative's tough on crime agenda. The Conservative government has developed a tradition now bringing forward measures to amend the criminal code through private members' bill, and this is another example. I asked the member opposite who sponsored this bill why he chose to have this issue addressed as a private member's bill, when we know that it is not reviewed by the Department of Justice to ensure accordance with the Charter and the Constitution. Mr. Speaker, as I mentioned earlier, I'm not a liar and I'm not a judge, so I will refer to the experts. I will quote Stephen Sullivan, first ombudsman for victims of crime, and I quote, "This legislation is nothing but smoke and mirrors. I do not believe that many judges will sentence a criminal to life in prison with 40 years without the right to parole. Judges simply will not do this. A life sentence, 24 years, already means that a person who presents a danger or a risk will not have access to a parole hearing, although the family must still be present at hearings. As well, this will apply to a very small number of criminals, those who abduct, rape, and murder one victim. Such sordid crimes are rather rare. This measure would be used one or two times a year at best, but would not change anything for the victim's family. Mr. Speaker, if the law works as it is currently, and it is used by judges efficiently, why suggest Bill C-478 if not for political agenda? J'aimerais aussi citer deux autres experts.
I'd also like to quote two other experts who've spoken out on the bill and whose remarks have led me to believe as parliamentarian that this is not something we should be supporting. I will quote Michael Spratt, who is the head of the Criminal Lawyers Association of Ontario. Bill C-478 is not something that offers anything to victims of crime. Now, I heard the member opposite say that this is a bill for victims, but it doesn't do anything. It doesn't change anything for the victim. In fact, it will. The victim will be punished longer, but the victim will have gone through the crime, experienced it, regardless. Now, until we have a better system for rehabilitation and to help people in jail to prevent them from reoffending. And I've worked in the prison environment. I taught in a prison, so I can tell you about the system. It is not working. This isn't going to help victims. Well, they prepare plans oftentimes in prison, but there isn't psychological assistance for inmates. If we wait simply another 15 years, is that going to help? No. At any rate, I'll get back to the quote that I was reading from. So Michael Spratt said that even if the objective of this bill is to spare families from having to participate in hearings, in the case of first-degree murder, there are no such hearings before 25 years, and in other cases it's every 2 years. By extending ineligibility for parole from 25 to 40 years. And this gentleman said, well, why those numbers? We would face constitutional challenges. This would be deemed counter to the Charter. And the outcome would most likely be that people would be pleading guilty, jamming up the system. There would be no incentive for rehabilitation, and hope for rehabilitation is what should, Mr. Speaker, be present for people in jail. We send people into prison. Of course, it is to pay their debt to society for what they've done. We understand that principle. But what's important in the process is rehabilitation. Adding another 15 years to a jail sentence is not going to make that person a better citizen when he or she is released. That's what we should be focusing our efforts on, Mr. Speaker. Now, to continue the quote, the impact will be disproportionate for third parties, such as someone who joins in with a gang, needs to be initiated. This bill doesn't do anything for victims or their families, end of quote. And the last quote that I wanted to mention comes from the Canadian Bar Association on this bill, C-478. The association does not believe that Canadians would be well served by a system that would force inmates to spend the rest of their days behind bars without any hope for being released. Even people convicted of homicide, the prisoner needs to know that there is a hope. Once they have served their time behind bars, there is a possibility to return to society and to play a useful role in society, provided that their behavior warrants the extending of this privilege. So all experts have said this is what is important. They focus their comments on rehabilitation and the importance of that. Now, we're talking about the serving of a sentence. When you serve a sentence, that is paying back a debt to society through the prison system. It's time paid back for the crime that we've committed. Now, I would like to insist and emphasize, Mr. Speaker, that if there is no one who's going to help those victims at present as the Conservatives are saying, well, what we have here is a bill. It's such that a person is going to be in jail for another 15 years. There won't be more services for rehabilitation, no more education to help the person to reintegrate society after release. Conditional release doesn't take anything away from the fact that these people must serve a prison sentence, in some cases a life sentence. Once released, they will still be monitored. Their release could be suspended or revoked, even or through the breach of a condition of release. So the comments that I've mentioned here today came from experts. It was the president of the Criminal Lawyers Association of Ontario, the Canadian Bar Association, the Victims Association. They're all opposed to this bill, and those people are experts, people we need to place our confidence in. Seeing as how I don't have much time left, Mr. Speaker, I will conclude by saying that Bill C-478, even if the government says it is to protect victims, on the surface, that is not the case. It doesn't deal with people who are convicted of life in prison, families won't benefit, and this is just a smokescreen being put forth by the government. It's being brought in through the back door by a private member, and it will be inconsistent with the Charter. For those reasons, Mr. Speaker, I will be, and my party will be, voting against it, and I hope that colleagues throughout the House will do the same.